to welcome all of you to the Chicago-Kent Law Review Virtual Symposium on Religion and Secularism in a Liberal Democratic Society. And I'm so happy to see everyone here for what surely will be an excellent symposium. And so this is the Law Review's annual symposium, and continuing in its tradition of holding an event each year that brings together scholars in law and other disciplines to discuss really important and often fast evolving topics on law and policy. And it's fitting, I think, that the Law Review does this, as Chicago-Kent has long prided itself on a tradition of scholarly rigor and accomplishment. And I want to give a special welcome to our speakers for today's event. I'm grateful to you for your participation in this symposium, and we are very fortunate that you are a part of it. I also want to recognize the symposium chairs, Professor Steve Heyman of Chicago-Kent and Professor Kathleen Brady of Emory University School of Law. Their respective and extensive scholarship on the intersection of law and religion, I think, make them simply ideal leaders for this event. So thank you so much, Professors Heyman and Brady, for serving in the chair role. As you know, this symposium today focuses on a theme that often seems so intractable within liberal democratic societies, namely whether and where there is room for bridging seemingly sharp divides between religion and secularism. And the topics that today's sessions will cover are critical ones, I think, because of the very far-reaching implications of any policy that serves to define the role of religion within societies that are structured by the rule of law. And this is evident simply from a glance of what some of these topics are. So religious exemptions and abortion laws, the protection of minority faiths and non-religious individuals, and the placement of the Ten Commandments within public schools. And based on the speaker lineup that we have today, I have no doubt whatsoever that the perspectives of each of our speakers will give us new ways to consider the symposium theme. And I just have to say personally, I love events like this because they enrich the intellectual life of this school, and my colleagues and I and our students really can never have too much of that. So welcome again. Thank you again for being a part of this event. And I'm now going to turn it over to Luke Winbery, who is the editor-in-chief of the Chicago-Kent Law Review.
Hello, good morning, and welcome to Chicago-Kent's Spring Symposium in Search of Common Ground, Religion and Secularism in a Liberal Democratic Society. My name is Luke Winbery. I'm the editor-in-chief of the Chicago-Kent Law Review. We're honored today to have with us a group of distinguished leading scholars in the field of law and religion. Their insightful contributions will be featured in Volume 100 of the Chicago-Kent Law Review, which will be published later this year. Before we begin, I'd like to extend my sincere thanks to Kathleen Brady and Steve Heyman for their tireless efforts in organizing the symposium and the upcoming issue. A lot of work goes into organizing these issues, and they've both been absolutely stellar to work with. I also want to thank our presenters for their valuable contributions, the moderators for taking the time to be with us today, Emily Barney for all her help with logistics, who's a librarian here at Chicago-Kent, and finally, our managing editor, Frankie Sikora, whose hard work made today possible. Again, thank you all for being here today. I look forward to a thought-provoking and engaging discussion, and I will now pass it over to Professor Steve Heyman, who will carry us through.
Good morning. I'm Steve Heyman. I'm one of the faculty editors and organizers of the symposium. I'd like to add my welcome to those that you've already heard from Dean Krug and from Luke Winbery. We're just delighted to have you all with us here today. And I want to give a special shout out to those of you who are participating from the West Coast and who literally had to get up at the break of day in order to be here. In recent decades, the divisions within our society have grown to the point where it sometimes feels like we're actually living in different worlds. And these divisions fall among many different lines, but one of the deepest is certainly the one that exists between the religious and the secular elements in our society. The goal of the symposium is to reflect on whether there are any ways to bridge this divide so that people who hold very different views can find a way to live together in a liberal democratic society. To grapple with this issue, we've assembled a stellar group of scholars from across the ideological spectrum. And over the course of the day, they're going to be exploring a wide range of topics from the history of religious liberty in America to the most cutting edge issues that are currently coming before the courts. I want to thank Luke and Frankie and everybody on the Law Review for all the incredibly hard work that they put into the symposium. And I'd also like to thank two of our most dedicated staff members at the law school, Emily Barney and Sue Jaden, for everything that they're doing to try to make the technology run smoothly. I just told Emily that I was so grateful that she's here because I can't count the number of ways that I would be dropping the ball if I were the only one responsible for running the tech. Finally, I want to introduce my fellow organizer and faculty editor, Kathleen Brady. Kathleen is a senior fellow and McDonald Distinguished Fellow at the Emory University Center for the Study of Law and Religion, and she did more than anybody to put this symposium together. Kathleen?
Thank you, Steve, though Steve is far too humble. As our panelists and moderators know, Steve has been flawlessly communicating with them for many weeks now. And he's also been working very hard behind the scenes with the amazing staff and students at Chicago Kent. I'd like to echo our thanks to all our panelists and moderators. It's an honor to have everyone here with us today. And finally, a quick word about how today will work. Our upcoming panel is on religious exemptions. It's going to be followed by a 15-minute break. And then at 11:45 Eastern Standard Time, we're going to begin our second panel on church and state. Then from 1 to 2, we're going to have an hour-long lunch break. And then at 2 p.m. Eastern Standard Time, we're going to begin our third panel on history, tradition, and the religion clauses, followed by another 15-minute break. And then we're going to start up again at 3:30 Eastern Standard Time for our final panel on cultural conflict and common ground. And now I'm as excited as you are to hear from our first panel. Thank you.
Good morning and welcome to everybody. I'm Sheldon Nahmod of Chicago Kent College of Law, and I'm delighted and honored to be here for what will certainly be an outstanding symposium on law and religion and culture. I will be moderating this panel, which will focus on religious exemptions. Later panels, as was discussed a moment ago, mentioned a moment ago, will deal with other aspects of the religion clauses. I can't help but notice, as a teacher and scholar for decades on the religion clauses, that the opening panel is in fact on religious exemptions, free exercise clause kinds of issues, because when I began teaching First Amendment and the religion clauses, we always began with the Establishment Clause and went on to the free exercise clause, which was in a sense marginalized. And that is no longer the case. The three distinguished speakers that we have today are eminently qualified to speak about the free exercise clause and religious exemptions. Each one will speak, as was mentioned earlier, for 15 minutes straight through in the order in which I introduce them, and then we'll have questions directed by each of the panelists, perhaps at each other, and then we'll open it up to questions generally. Our first speaker is Stephanie Barclay, who is a professor of law and faculty co-director of the Georgetown Center for the Constitution. Her research focuses on the role different democratic institutions play in protecting minority rights. She, like our other panelists, has published extensively and well in the Harvard Law Review, University of Chicago Law Review, University of Pennsylvania Law Review, and Yale Law Journal. And her topic The tentative topic or title of her paper is Necessity, Equality, and Religious Exemptions Requests to COVID-19 and Abortion Laws. Our second speaker is Mark Movsesian, and he is a professor and director of the Matone Center for Law and Religion, excuse me, at St. John's Law School. He has published in the Harvard Law Review, the Oxford Journal of Law and Religion, Journal of Law and Religion of Cambridge, Harvard Journal of Law and Public Policy, and many other journals. And he clerked for one of my favorite and really underappreciated justices of the Supreme Court, David Souter. A great man, Justice Souter, in my view. Our third and final speaker is Laura Underkuffler, who's a J. Duprat White Professor of Law at Cornell Law School. She's published widely in the United States and abroad in fields of religion and law, property law theory, constitutional law, and the role of moral decision-making in law. So with that out of the way, I welcome our first speaker, Stephanie Barclay. Thank you.
Thank you so much for that introduction. And thank you so much for the chance to be part of this symposium. I really appreciate all the work that Steve Heyman has done and Kathleen Brady and the Chicago-Kent Law School and various members of the law school and the Law Review for their terrific work leading up to this. It's such an important topic, and so I'm glad to get to be part of this conversation. So for my topic today, I'm going to be discussing the question of when it comes to religious exemptions, what is the reason that courts look to secular exemptions? And what relevance is that playing in their analysis when they're trying to provide a religious exemption? And so by secular exemption, I mean, if someone requests to do something for a religious reason, take, for example, the Supreme Court's case in Holt versus Hobbs, where you have a Muslim prisoner who's asking to be able to grow a half-inch beard for religious reasons. What a secular exemption is when the government is allowing that same sort of activity. They're allowing other inmates to have a beard, but they're allowing them to do so not for religious reasons, for secular reasons. What evidence is that secular exemption offering? What legal role does it play in the analysis? And in particular today, I want to talk about how that question arises in the context of requests for religious exemptions to abortion laws, laws that prohibit abortion, such as the one that we saw in Indiana, and also what we might learn about this question for some of the disputes that arose in the context of COVID. Some of this also relates to the Supreme Court's doctrine that scholars such as Doug Laycock have called the most favored nation doctrine, or the most favored nation theory, which is the idea that if there's just one secular exemption, then the Supreme Court has said that government has to provide a religious exemption too, or at least it has to satisfy strict scrutiny. If there's just one secular exemption, it has to satisfy strict scrutiny. And part of the debate is, well, does it basically mean that they must provide a religious exemption? Does it basically mean that the government has automatically lost strict scrutiny? I don't think that's the best way to understand what's going on right now at the Supreme Court, so I'm going to talk about that a little bit more. I'm going to be building on also an argument that I make in an article called Constitutional Rights as Protected Reasons, forthcoming in the Chicago Law Review, where I think sort of more generally and conceptually about what is the work that having a right is doing and that doctrines like strict scrutiny are doing. And I think first and foremost, when we constitutionalize a right, or you could think about quasi-constitutional statutes like RFRA that are creating rights, they're doing two important things. First, they're saying that there is now a first order reason why we're going to protect this right, here, religious liberty. And that's a reason that's not just applicable to judges analyzing cases, but to political actors. There's now a reason why you might want to try and be cautious and accommodating and protective of religion. And then the other thing I think that a right is doing is it creates what's called an exclusionary reason, which means that there are some justifications now for government action that are off the table. Some of those are obvious, like we wouldn't want government to act to limit religion based on hostility towards religion. In fact, some philosophers of practical reason would say that's not even actually a reason at all, because that shouldn't count in favor of doing anything. But there are other sorts of justifications that they're benign. There's nothing wrong with them. They're just not the types of reasons that we accept for interfering with an important right like religious liberty. And I think the Supreme Court has told us that generally cost is a reason that is not good enough to interfere with religious liberty. So that's just excluded. The government can't rely on that as a basis for saying we don't want to protect someone's religious liberty. And mere convenience, administrative convenience, is something that is generally excluded as a justification for government wanting to not protect religious liberty. So I'm going to talk about that a little bit more, but one of the other things that I think is important for courts to do is there are going to be then some reasons that are permitted for government to limit religious liberty. Public health is often a paradigmatic example. Let's just assume for the sake of discussion that protecting public health means protecting against permanent permanent interference with the normal function of the human body, or long-term interference with the normal functioning of the human body. And so the government is trying to prevent something from happening that would do that. There's also often the question that arises in these cases where we say, yes, that's a justification that government can act on. But is that justification, in fact, in conflict with the religious liberty here? With the first order reason that gives us reason to protect the constitutional interest or the RFRA interest, RFRA being a statute that's called the Religious Freedom Restoration Act. Because if those two things aren't in conflict, then there's no reason for government to use that justification to override religious liberty. Government should be able to, and courts pressure government to find ways to both accomplish its goals and to protect religious exercise. And we don't have to compare which is more important to do that. We don't have to weigh them. We can have what economists refer to as a Pareto efficient improvement, whereby you can make one party better off without making others worse off. And so it's better all around if we can find those sorts of solutions. That's what I think the work of strict scrutiny is often doing, is to try and find a way to see if there is, in fact, an opportunity for those sorts of improvements. And looking to things like secular exemptions helps provide evidence of that often. It helps provide evidence that government might have ways to both accomplish whatever important interest it has and protect this important right. So that I think is function number one that secular exemptions are doing. Function number two is if government has so many secular exemptions that its law looks like Swiss cheese and it's basically only regulating religion, at that point we might start to become skeptical that in fact the government's interest is what it says it is. And we might start to be skeptical that maybe the interest is serving as pretext for something that is more invidious or more hostile towards religion. Note that that's not the only reason we look to secular exemptions. In the first category I was talking about, it can simply just be evidence that there's a better way to get this done. But in the second category of reasons why religious exemptions are relevant, when they're really proliferating, the court has sometimes expressed concern that what the government is doing is basically gerrymandering their law so that they will only affect religion. This was relevant in a case called Lukumi, where there was a religious group, the Church of Babalui, that wanted to engage in animal sacrifice, ritual slaughters of animals like chickens for their religious practice. And the city was not happy about this. They passed a resolution basically condemning this sort of religious practice. And then they passed a series of laws that prohibited animal slaughter, but then exempted just about everything else other than the religious exercise. And here the Supreme Court was like, yeah, we're skeptical. It seems like this is aimed at and not neutral towards this religious group. The third category, which is relevant, particularly where we have a doctrine that requires us to look at whether something is compelling or not, is I think courts are hesitant to say, I subjectively think this interest is compelling. And so that's going to be the basis on which I decide if this government justification is in or out. But what courts have sometimes done when they're looking at exemptions is to see, are you, Congress, treating this as compelling when there's a brand new interest that we've never seen before, we haven't decided if this type of interest is permitted or not. It's on the borderline. And so we're looking to see, have you, the government, been treating this interest in a consistent way is important to you? I think that's a marginal category, often less relevant in these cases, but one that's worth thinking about as well. Okay, so I'm going to talk about how some of these categories were relevant in the Supreme Court's analysis in Holt versus Hobbs, in the COVID context, and then I'm going to talk about how I think they ought to be relevant to the question of, should we have religious exemptions from abortion laws? So in Holt versus Hobbs, where this prison inmate was asking to be able to have a half-inch beard, the fact that the government there allowed secular beards was something that the Supreme Court said they thought was relevant to the fact that that meant that they could both protect religious exercise, they could have beards, and protect prison safety as well. And the court didn't just look at that prison in Arkansas specifically, where the case was arising from. They looked at things that other prisons were doing as well, 44 prisons across the country and the federal government. And I think that's an indication that the reason that the government was looking at secular treatment of beards and of hair in that case wasn't purely to see, are you, the government, being even-handed? Are you treating the religious groups with equality? It wasn't just an equality value. It was an evidentiary function. Do these secular treatments of beards and hair show us that there's a way where you, government, can do both? And one of my favorite moments in that case was where, at oral argument, when the lawyer for the prison was arguing about the concern that inmates would hide weapons in their beards, Justice Scalia said, well, can't you just have the inmate run their fingers through their beards and then all the small revolvers will fall out? And the government attorney really had no answer for that, because that was also that was the type of solution that they were using for secular beards. So the secular exemption there pointed to this opportunity for a solution. Now, the government also tried to say, well, we're worried about having our staff anywhere near a prisoner when they're doing that sort of a search that could create some sort of risk for our staff. And then the court said, no, now wait a minute. You have your staff be near prisoners all the time for searching of that nature. And so, in other words, we're skeptical. We're skeptical that that's really the reason why now suddenly you're worried about this infinitesimally small risk that you allow everywhere else. And suddenly that's too big of a risk for religion. That seems like that's no longer really the justification here for why you're trying to limit religion. Notice that in this case, we are disputing whether or not, in fact, the harm that the government is worried about would occur. It's not as though the prisoner is saying, I must harm security guards in order for my religious exercise to be successful. That the harm is not constitutive of the religious exercise. The prisoner is perfectly happy to exercise his religion if, in fact, it were truly the case that no one is going to have the harm befall them that the government is worried about. That same sort of issue is going on in the COVID-19 context, where the government is trying to figure out, can we allow religious groups to gather or perform religious exercise in other ways consistent with our need to prevent the spread of COVID? And in these cases, again, there's nothing about the religious exercise of individuals who want to gather in churches that requires the spread of COVID. They will be thrilled, and in fact, they argued in their briefs that the way in which they were willing to gather with appropriate precautions and masking and social distancing would not spread COVID. So there's an evidentiary dispute about, is in fact the harm that the government's worried about going to occur in this case? That's different in the context of requests for exemptions from abortion laws. So let me give you a little bit of background. In Indiana, the government has passed a law that prohibits abortion after conception, save for some exceptions, things like rape or saving the life of the mother, and a series of other things. So, and also, as I'm sure people are familiar, the Supreme Court in Dobbs said that states have the right to define human life as beginning with conception, if they so choose to. The Supreme Court has also said in a case called Krug and other cases that protecting against loss of human life is the quintessential reason that is a justification for limiting rights, including religious exercise. It is a quintessential compelling government interest under the current strict scrutiny standard. So Indiana has chosen to define human life as beginning at conception, and the Supreme Court has said defending human life is a compelling government interest. So the real question is, what do we do about the fact that Indiana has some secular exemptions for its laws for things like rape or the life of the mother? And here I would argue that for the reasons that we just talked about, those secular exemptions, they might trigger strict scrutiny, but they do not mean that the government wins under strict scrutiny, because they're not pointing to, as an evidentiary matter, the fact that there might be some way in which the government can both save the human lives at issue and protect religious exercise of Jewish plaintiffs who argue that their religion requires them to get an exemption. The parties have conceded that there is no less restrictive way for the government to protect those human lives. And so the secular exemptions aren't performing that evidentiary function anymore, where they're pointing to the possibility for a win-win solution. The religious exercise of the Jewish plaintiffs in that case requires the destruction of human life. It requires the abortion. And so we are in a situation where there's a zero-sum conflict between the religious exercise and the harm the government wishes to avoid, because that very harm is constitutive of the religious exercise. In the same way it is in...
Stephanie, please forgive this interruption. You have a couple of minutes left, 2 minutes left.
I saw that. Thank you, Sheldon.
Thank you. Okay.
This is also true in cases where individuals claim a religious exercise to be able to have an assisted suicide performed, or another case coming out of Indiana where a mother claimed a religious exercise to seriously beat her child physically. Those are other cases where the very harm that the government is trying to avoid is constitutive of the religious exercise itself. And so we don't need to look to secular exemptions as evidence of, is there a way the government can avoid that harm and protect the religious exercise? The parties have conceded they cannot. It's also not a case in Indiana where the secular exemptions suggest that there's some sort of pretext, or that the government is not, in fact, interested in protecting human life. And it's not a case where we don't know if protecting human life is a compelling interest. The Supreme Court has said that protecting human life clearly is. And if the opposite were true, if the argument that those in Indiana were successful, it would mean that in cases, in contexts like in Oregon, where the government does allow assisted suicide, that means that if the Aztecs moved in and wanted to start practicing human sacrifice, that the government would lose under strict scrutiny and would not be able to protect against that religious exercise, because somewhere in their law, they have allowed some exemptions for the taking of human life in other contexts. That can't be the rule. That's not the rule the Supreme Court has applied anywhere else. And I don't think that that's the way that secular exemptions are most helpfully understood in our larger framework of how we find ways to live and let live, to have win-win solutions, to both protect religious exercise and let government accomplish its goals, the real work that usually that sort of analysis is doing. And I'll go ahead and stop there.
Thank you, Professor, very, very much. We now move to our second speaker, Mark Movsesian, and the tentative title for his talk is, for a second, let me make sure I've got this right. Status, Conduct, Belief, and Message, the wedding vendor cases. Take it away, Professor. Mark?
Can people hear me?
Yes.
Great. Okay, thank you. Well, I want to begin by saying thank you to Steve and Kathleen, and also to the members of the Law Review for having me here today. I very much appreciate your having me. Sheldon, since you mentioned Justice Souter, I wasn't planning on this, but I happen to have my bobblehead collar of Justice Souter right here with me, so I wanted to give him a shout out too. Well, so I'm going to speak today about one of the more neuralgic episodes in the U.S.'s ongoing culture wars, that is the wedding vendor cases. And these, I think, are cases people are familiar with. There are cases in which small business owners decline for religious reasons to serve at same-sex weddings. Now, one shouldn't exaggerate the frequency of these cases. Relatively few vendors in the U.S. apparently have objections to serving at gay weddings, although that may depend in part where one lives. And I know Laura's written about this in her paper. And even vendors who object to serving at gay weddings typically don't claim a right to serve gay customers generally. In fact, they typically affirm that they're willing to serve all customers. But their refusal to serve at same-sex weddings has had great symbolic importance, and it's caused pain and offense for gay couples, and it's also occasioned litigation under state public accommodations laws. Now, the wedding vendor cases have been argued largely in terms of conceptual distinctions among status, conduct, belief, and message. The business owners typically contend that they don't discriminate based on status. Rather, they decline to participate in conduct that they find objectionable and/or send a message that they approve of conduct that they don't. In fact, applying public accommodations law to them in this context violates their own free speech and free exercise rights. It might even amount to status discrimination against them based on their religion. For their part, the customers and their supporters, including state civil rights authorities, counter that the vendors do indeed discriminate based on status, because when it comes to sexual orientation, status and conduct can't be separated. Because only gay couples have same-sex weddings, declining to provide services for such weddings inherently discriminates based on status. Moreover, public accommodations laws affect conduct, not belief or speech. The vendors remain free to believe what they want and express what personal messages they wish. At most, the laws affect expressive conduct, which the state can restrict to further an important or substantial state interest, like ensuring access to goods and services in the market. Note that each side tries to avoid the basic conflict in these cases between anti-discrimination laws and constitutional guarantees of free exercise and speech by arguing that the conflict doesn't really exist, either because the vendors don't discriminate based on LGBT status or because public accommodations laws don't affect free exercise or free speech. Avoiding a difficult issue is a standard tactic in litigation, and it makes sense in this context, because the court has made clear that it too would like very much to avoid the conflict. In two recent wedding vendor cases, Masterpiece Cake Shop and 303 Creative, the court relied on peculiarities in the factual records to resolve the disputes on very case-specific grounds that made answering larger questions unnecessary. In fact, avoidance tactics are something of a pattern in recent cases involving public accommodations laws and religious freedom. In Fulton, the court discovered that Catholic social services didn't qualify as a public accommodation under Pennsylvania law, even though everyone in the case assumed it did, thereby avoiding larger debates about LGBT rights and religious freedom. I discussed these cases at length in my paper, but in the interest of time this morning, let's just focus on Masterpiece Cake Shop, which highlights the difficulty of one of these conceptual distinctions between status and conduct. In Masterpiece Cake Shop, a gay couple tried to order a wedding cake from a devout Christian baker. The baker declined from religious conviction. Baking a cake for a same-sex wedding, he said, would amount to, quote, personal endorsement and participation in the ceremony and relationship that the couple was entering into. When the state civil rights authorities accused the baker of violating Colorado's public accommodations law, he objected that he had not discriminated based on a protected status. If anything, he had discriminated based on conduct. He didn't approve of what the gay couple planned to do on religious grounds and didn't want to be implicated in their actions. From his perspective, the distinction between status and conduct made sense. As a Christian, he believed that same-sex marriage was a sin. But Christianity teaches that one must distinguish between the sin and the sinner, and that's, he said, is what he tried to do. Separating status and conduct in this context isn't so easy, though. Contemporary American culture views sexual orientation and sexual conduct as intertwined. The conduct is constitutive of the status. From that perspective, it makes little sense to forbid discrimination against LGBT persons, but allow discrimination based on conduct that LGBT persons say is central to their identity. Ironically, for the vendor cases inevitably pit LGBT persons against religious believers, religion is another such category. With respect to religion, too, it's often hard to distinguish status from conduct as a practical matter. A tax on wearing yarmulkes, the court said, is a tax on Jews. In separate opinions, the concurring justices in Masterpiece Cake Shop debated this issue. Justice Kagan maintained that the baker had discriminated based on sexual orientation, since he would sell a wedding cake to a straight couple, but not a gay couple. Justice Gorsuch disagreed. The baker would not bake a cake celebrating a gay wedding for anyone, gay or straight. It was the kind of cake, not the customer, that mattered to him. One might think it far-fetched that a straight person would request such a cake, but it occasionally happens. In Masterpiece Cake Shop itself, the baker had evidently refused to sell a cake for the couple's wedding to the mother of one of the two men. Now, Justices Kagan and Gorsuch, in my opinion, each made plausible arguments that turn on conceptual distinctions. It's genuinely difficult to reach a firm conclusion whether the baker had discriminated based on status or conduct. But the court was able to resolve the case without deciding that issue. Even assuming he had discriminated based on status, the court said, applying the public accommodations law to him violated the free exercise clause. State authorities had failed to treat the baker's religious convictions neutrally and respectfully. For example, 2 of the civil rights commissioners had made disparaging remarks about the baker's religious beliefs during the hearing on his case. So in Masterpiece Cake Shop, the court seized on a peculiarity in the record to avoid the basic issue. It's unusual, although perhaps not as unusual as it should be, for state officials to disparage traditional religious beliefs on the record. By making that fact conclusive, the court resolved the case on narrow grounds that limit the decision's effect. In fact, under Employment Division versus Smith, once the court determined that the state had failed to treat the baker's religious beliefs neutrally and respectfully, the next step should have been to apply strict scrutiny. The court should have asked whether the burden on the baker's religious exercise was outweighed by a compelling state interest, which the state had promoted in the least restrictive way. But the justices skipped that step. The state's manifest hostility to the baker's religious beliefs per se violated the Free Establishment Clause. Now, it's easy to see why the court might have wished to avoid the broader questions in the case. In practice, strict scrutiny operates as a balancing test. So applying strict scrutiny in that context might have required the court to determine which had more importance, the baker's free exercise rights or the state's goal of eliminating discrimination against LGBT persons in the market. It might have required the court to revisit earlier rulings on free exercise rights that said free exercise rights do not trump the state's interest in ending racial discrimination in the market, to declare whether race and sexual orientation are analogous in this context. Deciding the case on narrow grounds not only allowed the court to escape the difficult question whether the baker had discriminated based on status or conduct, but also to avoid broader questions about social policy that it evidently didn't wish to address. Now, in the paper, I described some of the other conceptual distinctions that come up in cases like 303 Creative and also Fulton, but I don't want to take time here to talk about them. Suffice it to say, at least in 303 Creative, the court relied on other particularities, namely the party stipulations, to avoid getting into the conundrums that I've talked about here. I can't get inside the heads of the justices, but one explanation for their reticence suggests itself. American society is deeply polarized along lines of politics and religion with respect to the conflict between LGBT rights and religious freedom in the marketplace. And in the paper, I discuss a couple of Pew surveys that make this very apparent. Given that polarization, the court might well believe that broad rulings would only inflame tensions further. Better perhaps to rule on narrow case-specific grounds, like hostile comments in the record or the parties' stipulations, until the culture reaches some sort of equilibrium on the broader issues. The approach is reminiscent of Alexander Bickle's famous argument for the passive virtues that counsel the court to avoid constitutional rulings that exacerbate interbranch tensions and intensify the counter-majoritarian difficulty. Now, it's true, in these cases, the court didn't avoid constitutional questions. In fact, the court held state action unconstitutional. But it did so in ways that leave the deeper issues unresolved and limit the wider impact of its decisions, and thus avoid antagonizing the situation even more. Now, to be sure, the court didn't have to grant cert in these cases at all, and the justices have not shied away from broad rulings that affect other polarizing conflicts in our society, like abortion. But perhaps the justices think of the conflict in the wedding vendor cases as different in some way. Perhaps they perceive something unique about government's attempt to compel speech that makes such an attempt unconstitutional per se. Perhaps they find the legal issues here especially challenging and uncomfortable, especially the lurking analogy between race and sexual orientation. Perhaps they feel more ambivalent personally about the rights and wrongs of this conflict, than they do about others. Whatever the reason, the justices' desire to avoid broad rulings is manifest. Now, as I say in the paper, there are downsides to a narrow, fact-bound approach. Lower court judges would benefit from clearer guidance from future cases, which will no doubt continue to arise. Narrow decisions prolong legal uncertainty and make further protracted fact-specific litigation unnecessary. And the court's decisions might suggest a kind of disingenuousness, a desire to reach predetermined results without making broad pronouncements that would irritate lots of people. Certainly, critics who are disposed to see the court as captured by religionist ideologues will interpret the wedding vendor cases that way, and I think there's grounds for that. Still, I argue in the paper that narrow decisions have allowed the court to manage these sensitive issues without exacerbating one of the nation's most neuralgic current divides. The court will most likely stick to narrow case-by-case adjudication and seek whatever escape hatches the records provide in order to avoid looking at the broader issues. In this way, the court will allow Americans to muddle along and come to some sort of practical compromise on the competing claims of LGBT equality and religious freedom in the marketplace. For those on both sides who believe their rights have not been fully vindicated, this will be gravely disappointing. In the circumstances, though, it might be the most prudent way for the court to do business. Thank you.
Thank you very much, Mark. It is good to hear Alexander Bickle's name again, as well as the passive virtues, which don't seem to be much with us anymore. Our third and final speaker is Laura Underkuffler, whom I introduced earlier, professor at Cornell Law School, and her tentative paper title is Simple Accommodation, a Solution for Conflicts Between Religious Claims and Secular Law. Laura, take it away, please. There you
go. Thank you. I appreciate this opportunity to speak. I'm following two terrific papers. I have to say that Stephanie's paper explores an area that is so important, as evidenced by the Fulton case and others, and has simply not been theorized the way she does it. That was terrific. And as far as Mark's paper, after I read it, I wrote to him and said, you've got it. I mean, I think it's very, very true. Every single word he says is very, very true. So the question that I want to talk about today is really something which is in the same cluster as the one that Mark talked about. And because it deals with religious exemptions, and in particular, it deals with a particular approach to the religion civil rights conflict that is out there, has been for quite some time in the literature. And I want to say at the outset that I know that many of the individuals who advance this theory have very seriously advanced this theory for the last 10, 15, 20 years, absolutely believe that it is an improvement over other approaches and so on, that they're sincere in that approach. My work is simply to illustrate that I see very serious problems with it on a theoretical level. And I'm going to talk about them today. Well, when it comes to the bitter conflict between religious individuals who want to have exemptions from particularly the civil rights laws that have been afforded to LGBT individuals, the field of this area is immense. I mean, it's true that there have not been that many court cases, but as has been acknowledged, I think, by many of the scholars operating in that field as well as others. The situation right now for LGBT people in society is not particularly promising. In fact, it is, some would say, an all-out war on them, but by everyone, including some state legislators, some state school boards. You know, it's a very serious systemic problem. So therefore, we have the collision of two extremely and strongly felt positions. So one would think, I suppose, if you thought about it superficially, one would say, well, the issue here is that we have to make a normative choice. As Mark indicated, which is more important? The civil rights protections for a particular group, which everyone agrees is certainly subject to a lot of persecution and so forth through history and even today, or the deep religious convictions of some individuals which have been in some ways honored in our historical traditions also. So we just have to make some sort of normative choice. Well, this particular body of work that I call the accommodationist body of scholarly work believes that there is another choice, and they labor to avoid the conclusion that it's simply a normative choice. Instead, they come up with a methodology, which they say is much simpler, even-handed, and in which both claimants win because of the neutrality and even-handedness of the process. The accommodationist proposals generally follow the following steps. First, the interests of each of the conflicting parties, the religious objector and the secular law claimant, which is, in this case, LGBTQ individuals, are identified. Next, there must be a weighing or balancing of the competing interests in which the relative hardships that each suffers are to be examined. If the hardship that would be suffered by the religious individual is greater, then the religious exemption must be granted. On the other hand, if the hardship faced by the secular law claimant is greater, then the secular law will be enforced. Well, the value of this approach, as I just mentioned, for the advocates of it, is that it's a normative-free, no normative choice, live and let live approach. It does not involve itself with the condemnation of either claimant. Rather, it's simply a dispassionate identification of the interest and the evaluation of hardships. The goal and the approach by both parties, for both parties, as these scholars often say, is that both will be, quote, socially apparent and acknowledged, unquote. And in this way, resolution can be achieved and the divisive moral issues can be avoided. So my enterprise is to say, does this proposal really live up to those aspirations? One of the most common examples, I think because it was both high profile and very clear, that is used in the accommodationist literature is the municipal clerk who refuses to issue a same-sex marriage license. And for the religious clerk, it's observed in this approach, the stakes in the case are very high. Religious beliefs are of extraordinary importance to the individual. Furthermore, if the clerk is forced to violate her beliefs, a religious believer, she will suffer special harm, because in this case, she really is left with no choice but to choose between her beliefs and her employment. Then we get to the other side. What about the same-sex marriage applicant if the religious clerk is allowed to simply step aside, which is usually what is suggested? The accommodationist position is that same-sex couple is entitled under secular law to the ability to marry. But that is the stake. That is what is at stake for the same-sex couple. Furthermore, that interest will be preserved if the religious objector refuses to process the couple's request, as long as there is someone else, another willing clerk, to take the religious objector's place. For that reason, the conclusion is the same-sex couple has no real complaint in this case if that accommodation is enacted. Simply passing the ministerial function to someone else will not hurt or harm the secular law claimant, because the secular law claimant will have what the real interest is, which is access to same-sex marriage. Well, what the advocates of this approach point out in this and other examples is that there is a tremendous advantage to this approach, they say, because the competing interests of the parties have been clearly identified and expressly compared. Religious rights, as a prima facie matter, enjoy presumptive protection. At the same time, those who are affected by the protection of religious rights are also considered. If the secular law claimant cannot receive the services from an alternate provider, another hotel, shop, restaurant, clerk of court, whatever, a hardship will be proven. And in that case, the presumed superiority of religious claim will yield. And sometimes it's even stated that this is really an advance for the secular law LGBTQ claimant, because it provides a hardship exemption from what would otherwise be a presumptively powerful and winning religious right. Well, the question is, does this method really implement even-handedness, value neutrality, and so forth and so on? In some ways, I think superficially, yes, but in other ways, more deeply, no. At the outset, these proposals elevate claimed religious rights and demands to a status of prima facie or presumptive validity, with secular claimants then left to rebut that. However, by elevating the religious claims to what is essentially an initial status of presumptive dominance, it is apparent that a normative judgment, in fact, has been made as to that issue. Now, you could say, well, presumptive dominance is undesirable in an approach that claims to implement even-handedness and so on. It might be forgiven if, in fact, the religious claims, or I'm sorry, the secular claims are given a full and fair treatment as to the competing interests that they assert. So we need to look at that. In these cases, the interests of the LGBT claimants can be easily imagined. They are the right to be served, the right to equal treatment, or any other way that the gap between the law's guarantees and the honoring of their religious refusal can be captured. This is true whether it's a denial of a marriage license, a marketplace purchase, a hotel room, whatever it might be. The accommodation approach readily recognizes that LGBT individuals who face marketplace discrimination will experience, and this is a quotation from quite a few of the most prominent writings, frustration, anger, and feelings of shame. However, in the accommodationist calculus, none of these have any bearing on the outcome, which is, to me, interesting. Why is that? Because, in their view, the issue is the achievement of the particular product, status, marriage license, whatever. In fact, these other collateral issues are, in fact, not substantial enough to be a part of the particular calculus involved. They are rather simply dignitary harms, and dignitary harms are not some sort of out of the ordinary or extraordinarily painful experience. They're simply too subjective to the individual, too unjustified by external observers, too unsubstantial to really have a role in the calculus itself. The idea that discrimination of any kind simply triggers transient emotions that are unimportant in the big scheme of things, and that will or should quickly pass from conscious thought, is hard, however, to reconcile with what these same scholars acknowledge that people in that position experience. Some accommodationist theory goes a little farther and says, well, if it's a case of personal denial, that is more persuasive in favor of the denied individual and the calculus than if it's a theoretical denial. However, the solution for that, once again, does not really vindicate that experience. For instance, there's a theory that we could just have signs up or something like this, notice to the LGBT individuals, so they don't even approach that establishment. Doesn't really get to the core of the matter in my view. One of the other big issues here, and I realize I don't have much time left, is the idea of hardship that the accommodationist calculus uses. Hardship is a very familiar term. We think of hardship, we think of denial of food, denial of shelter, something in a very concrete and material sense. I think that the use of the hardship as the test, once again, sets the stage so that the actual harms to the civil rights claimant are therefore not of importance. We normally don't say someone suffered a hardship because somebody else insulted them or whatever. It denigrates the kinds of harms that these clients or claimants actually experience. So, to quickly conclude, I'm not saying that the goal of accommodationist theory is to cause pain to LGBT citizens. I don't believe that. I believe the accommodationist theory is sincere in its desire to find a way to grant both gay people and religious conservatives space wherein they can live out their beliefs, values, and identities, which is what is often stated. The problem, I think, is that this is not possible when the goal of one side in its unavoidable effect is the denial of civil rights to the other. When one person's religious beliefs explicitly require that others be denied their civil rights, a deep and irresolvable conflict exists. We do not allow people to engage in theft, murder, fraud, and so forth simply because the religious beliefs command that they do so. The simple answer is not enough. We have to have some evaluation of the societal interests at stake and the religious interests at stake, something which, as Mark so well explained in the Supreme Court level, we have failed to do. And I think that refusing to deal with that deeper question will only, in the end, construct what feels like an incomplete account and a failure to reckon with the real choice involved. Thank you.
Professor, thank you very much, and all three of you for outstanding and provocative presentations. I would like now to offer each of our speakers, who I hope are unmuted, have unmuted themselves, to ask questions of one another, and then we'll open it up to questions generally. Stephanie, Mark, Laura, go for it, if you want.
I guess
Sure. Okay, Laura, no,
Mark,
please,
go
you go
ahead.
first. No, that's okay. No, that's fine.
I was going to ask a question of Stephanie, which, and I don't know the answer to this, so it's not some sort of pitfall or something. But in your analysis, and I may be wrong about this, you seem to talk about how when we're looking at the question of exemptions, we would look at the question of exceptions from law. And that definitely is the way the Supreme Court has approached it. I absolutely agree with you. What occurred to me is, are those two really on an equal footing? Because we have, let's say we have religious exceptions that are specified in the Civil Rights Acts, that somehow means that we should have, that the case for religious exemptions from law are stronger. You know, it's a different kind of thing. In the one case, we're saying the legislative process developed these exceptions and weighed all of these considerations and came up with this limited variety. On the other case, we're saying exemptions are something that individuals claim for their own individual religious reasons. So I'm just curious whether you've done any thinking about that yet, or whether you have any thought on it.
Yeah, I think that's a good question. So this was relevant in the Can you hear me, by the way? I put my earbuds in.
Yeah.
We hear you
Okay.
beautifully.
This was relevant in the contraceptive mandate litigation, where some of the exemptions that groups like the Little Sisters of the Poor were pointing to were the fact that um, other religious groups had been exempted as long as they were closely affiliated enough with the church. And so they were pointing out, look, you have found ways to exempt the Catholic bishops. Why won't you exempt the Little Sisters of the Poor? And so if we're thinking of exemptions the way that I was talking about in my first category, where like they are evidence that government can do both things. It can advance whatever justification it is, their access to contraception for women, and protect religious groups, then exemptions for other religious groups are also relevant for that sort of evidentiary purpose. They point to the fact that Congress had figured out a way that we can still get contraceptives to women and still exempt certain religious organizations, which means that there's at least a reason under strict scrutiny we're going to look really hard at the fact that that suggests government could possibly do the same thing here for the Little Sisters of the Poor. And so whether the exemption is for secular reasons or religious reasons, I think that evidentiary relevance that it poses is the same.
Mark, you were going to say something a moment ago.
Yeah, thank you. So thank you first, Laura, thank you for your kind comments. I had just comments for both of you. I like both papers too very much. I thought both very, very thought-provoking. For Stephanie, just a small thing. I would suggest you go back and look at Reynolds and also Davis versus Beeson from the 19th century, the polygamy cases, because I think those are cases in which the religious exercise is constitutive, the harm itself is constitutive of the religious exercise. And I think it might be useful to go back and look at what the court said in those cases. I think it would sort of support the theory you're bringing here, and there's an example of that. For Laura, I would say, look, obviously, Laura, I agree with you. There's a normative choice here has to be made. The only thing I would say is, as you were talking again, I thought about this, that when you say, well, we are denying people's civil rights, that's actually the question we're asking, right? We're saying, is it a denial of civil rights in this particular context to be told someone has a religious objection? And the free exercise clause itself, that the free exercise clause itself suggests that religion should have, if not dominance, should have some important role in the decision that's being made. So, of course, I agree with you. Ultimately, it is a normative choice, and we have to make that in some just way. But I would just point out those two comments anyway for you to think about.
Any other questions from our panelists?
I'll also add that I really enjoyed both of your remarks. One question I had for you, Laura, and obviously the framework I'm presenting is trying to think about, is there a way to do strict scrutiny that is not balancing, that is not just asking the court to pick which interest is more important, but is identifying some interests are off the table, and then for the interests that aren't off the table, are they actually in conflict with religious exercise? I read the government or the court's cases in decisions like Sultan and Masterpiece Cake Shop, and maybe even 303 Creative, to suggest that the government's articulated interest of preventing dignitary harm alone to people it's just not a permitted reason. That's not a reason that would ever trump First Amendment interests. So it's just excluded from consideration. There are other sorts of civil rights interests and anti-discrimination interests that would be relevant. So if you have like denial of material goods or opportunity to get a job or things like that, I think that then the court would look harder at, okay, is that in conflict with the religious exercise here? But my read of those cases is that if dignitary harm had in fact been a reason to trump First Amendment rights, then the cases would have gone the other way. And the court talked about how, we've long held in the context of speech that someone's dignitary harm just can't be a reason why we override speech, or we would very rarely protect freedom of speech. So I'm curious what you make of that. Like if we disentangle, we don't just say at a very high level of abstraction, civil rights protections, but we say like, what is the particular good that the government is, or justification that the government is trying to advance for these people here? Then it strikes me that there's a bundle of things that are relevant under civil rights acts that government might point to, and not all of them are reasons that would be sufficient to interfere with the First Amendment. So I'd just be interested to hear you reflect on that, see if you disagree, agree, and what your thoughts are.
I think you're absolutely correct that that's what the court has basically said, at least in the religion context. They've bundled all of the experiences of the presumably LGBT individual, the Black individual, the female individual, the Jewish individual into a box, which they say is just dignitary harm and therefore not particularly persuasive when it comes up against a religious claim. At least that's the implication. Of course, they have never addressed race, religion, and so forth as a claim in a discrimination context against a religious claim. But I'm not saying that you don't look at the interests involved. You have to look at the interests involved. In fact, it's my position that I am not opposed to exemptions in every context at all. In fact, I'm currently writing a book on this subject, just about completed, and it's not a case of we just don't look at it. We just sit there and think to ourselves, which is more important? You know, you have to look at the interests that are the competing interests that are involved. My problem with the accommodationist approach is that the whole thing is structured and executed so that the interests of the civil rights claimant are of no importance, right? It's predetermined right from the outset. All of the importance, you know, if an individual walks down the street and sees a sign in the window that says, gays not served here, or sees on a website, no Jews permitted in our establishment, there is a harm there. I mean, they could say there's no harm, but I guess I just fundamentally disagree. There is a harm. And to that kind of harm has to be recognized. We've certainly recognized it in this case of race discrimination, right? Absolutely, we recognize it. We'd never accept 90% of what has gone on in the way of statements about LGBTQ individuals and their harms if the claimant was, if it was a race claimant, national origin claimant, gender claimant. We simply wouldn't. So my complaint isn't with the idea that we compare interests. We have to compare interests. The question is whether the interests are really being portrayed fairly. That's, at least in my view, that's the issue.
Let me interject and invite the participants to write in any questions in the Q&A box, and we'll look at those. I have a question for all of you, which harkens back to the 19th century. Or if you don't like the 19th century, it's a parallel question for the last part of the 20th century. I'm thinking about your views, and this is either a really hard question or an easy question. What are your views of Reynolds versus United States, the Mormon polygamy case, decided in 1879, or perhaps more controversially, what are your views of the viability, the soundness of, you know what case, Smith? Smith decided by the Supreme Court in, I think, 1990. So this is either right down the middle or it's a screwball. I'm not quite sure what the question is. Anybody? Any of you?
I have thoughts, but I'm happy to defer to my co-panelists first.
I can say something, I guess, if Mark, if
Please.
you
No, you go first.
yeah. Polygamy, well, there the question is whether or not the practice of polygamy in the United States is going to be so harmful to the social fabric that it needs to be prohibited, right?
Right.
The reasons given at the time were on the basis of Christian ethics and morals and so forth. We generally today do not consider such overt references to sectarian ideas as being something that is acceptable. But the real question is polygamy something that today would be so harmful to the social fabric? You know, I don't know. I mean, to me, I'm not a polygamist, so I don't really understand that position. Of course, it's also a religious position, so then the question becomes whether
Right.
somehow the fact that it's a religious position. But it's basically the same issue, which is how much harm does this particular religious exercise create, and that is going to be a complex determination with all of the facets of it and the social ramifications considered, versus what the society is claiming. Now, we've changed a lot of our views on things over the years. Maybe polygamy is one that should be revisited, but that's, I guess that's it. As far as Smith, I rarely agree with Justice Scalia, but I absolutely agree with him in that case. The idea of simply random exemptions being granted on the basis of individual prerogative is a very difficult thing. We are now veering very far away from Smith. In fact, I think most of us are waiting for the court to strike it down.
Right.
So
Yeah, I would say on Reynolds, I already spoke about it. I think Reynolds fits into Stephanie's theory about a case in which the harm is constitutive. At least the court at the time thought the harm was constitutive of the religious practice, and that's, I think, that is, and I agree with what Laura said about that's what the court thought, and it's an example of how if the court or if the society at large thinks that there really is an interest in stopping the practice, then they will stop the practice, and the court will allow that to happen. About Smith, I sort of have some sympathy for Smith too, I guess. I would say I'm not sure what's left of Smith anyway at this point, because the court has indicated that, so Smith says that if a law is generally applicable and neutral, doesn't target religion, it just gets rational basis review, otherwise strict scrutiny. But the court has seemed to suggest lately that if there's even the theoretical possibility of an exception, that means the law is not generally applicable, in which case you get to strict scrutiny, and strict scrutiny means basically the government loses. So I'm not, except in a case like Reynolds or something like that, where there really is a compelling interest that people think exists. So I'm not sure what's left of Smith anyway, really. I also have Justice Scalia, a bobblehead of him back there. I can bring that out too if you want. But I've already shown you Justice Souter, so maybe we'll leave it at that.
Okay, Stephanie, your thoughts, please. I think you got a law review article coming out on Smith. Do you not? Do I remember that correctly?
You know, I've written too much about Smith. I counted with my husband the other night. I've written 8 different articles that are relevant to Smith, which is a little bit ridiculous. So I have thoughts about this case. Yes, you did notice I have another one coming out recently where it was sort of a fun project. My co-author and I parsed Justice O'Connor's recently released Supreme Court papers and looked at the decade leading up to Smith and what the court was thinking about in that case. And so that one's coming out in the Penn Law Review. It is just an interesting sort of behind the scenes look at some of what was going on. So Reynolds, here's how I would think about it under the framework I've proposed. First of all, some of the reasons that the government was acting there to limit polygamy, I think were not permitted, excluded reasons. I mean, there was a lot of statements from different government officials about how the Mormon faith wasn't Christian faith, wasn't worthy of being protected by the Constitution. To the extent that justification is motivating government today or any day, like that's just not a real reason for that we would permit to be weighed against religious exercise for government to say, I don't think your religious belief counts. That's not a good reason. But there were other reasons that the government was concerned about. Harriet Beecher Stowe, who obviously was one of the great champions speaking out against slavery, was also one of the great champions speaking out against polygamy, because she believed, like many people, that polygamy required women and children to be enslaved. And that's why the Republican Party at the time of Reconstruction pointed to the twin barbarisms of slavery and polygamy. They viewed polygamy as a type of slavery. So one thing I would just, like a friendly amendment to what you're saying, Mark, is the government believed that the harm was constitutive of the religious exercise, that the religious exercise required slavery. But if that case had been litigated with any sort of evidentiary findings, the religious claimants would have disputed that, right? They would have said, no, our religious exercise doesn't require slavery of women and children and abuse of them. We can practice polygamy in a way that does not require those things. And so then it would have been an evidentiary question. Is there a way to avoid that harm or not? Which is most often what arises in these cases. It would have been different if the religious individuals would have said, yeah, like we like to enslave women and children. We must enslave women and children to accomplish our religious exercise. Then you have a context that's really on all fours with the other unique contexts I'm talking about, where there's no dispute that the harm is required by the religious exercise. So I think Smith was wrong because the court wasn't actually thinking about what's the meaning of the religious exercise clause, what is the textual meaning, what historically was it to understand to include. Michael McConnell and Doug Laycock have done some great historical work about why the religious exercise clause was meant to include religious exemptions. I've done some historical work looking at early court cases that engaged in something that looks like strict scrutiny to provide religious exemptions. So I think there's strong support for the view that Smith overrode purely on consequentialist reasons. That's why I think it's a good thing that, as Laura and Mark have identified, Smith has largely been eroded. It's mostly dead letter now because it's so easy to trigger strict scrutiny under general applicability or neutrality. And then under strict scrutiny, then we look hard at, is there a way for government to avoid the harm and still protect religious exercise? And Sheldon, I will just note for you that Andy Koppelman emailed us, which you may not have seen, and said he has some questions for the panel as well.
That's fine. I didn't see that on the Q&A, but I do have a couple of questions in addition to what Andy may ask. And let me start off with this question.
Andy's questions are in the chat for what it's worth. We had an issue, so we made chat available to the participants as well as Q&A. Sorry for the confusion there.
Okay. Let me get to Andy in a moment because Daniel Bennett asked this question for anybody, all of you. How do you see the future of religious higher education in the legal environment, especially given the potentially expanding ministerial exemption? Should I read that again? How do you see the future of religious higher education in the legal environment, especially given the potentially expanding ministerial exemption?
Well, I'll just start because there's another part of the paper I didn't actually write that I maybe will do another paper on, and that is I think the same issue about status, conduct, belief, message comes up in the education context too. And there's a case right now working its way through the First Circuit in which I think this is going to come up. It sort of follows the Carson versus Mackin litigation in which the court said that that you couldn't deny you couldn't exclude religious private schools, which are also public accommodations, from a state benefits program because it was exercising religion. It followed after another case in which said you couldn't exclude the school because of status. So now you can exclude the school because it is, practicing religion or teaching religion. But there now are a couple of cases in which some schools have said that they are not going to admit, I guess it's gay children or children of gay parents or something. I'm not exactly sure what. But the schools are saying, well, we're not discriminating based on status. It's based on conduct. We don't want to suggest we condone this conduct. And once again, the race analogy comes up because there are older cases like Runyon versus McCrary, which say that when it comes to education, a private school can teach racial segregation, but cannot exclude Black children. So I think that's going to come up here. And so I guess I'd say I see the same status, conduct, belief, message conundrums coming up very shortly in the education context too.
Thank you. I have a question, and I see Andy Koppelman's question, but I'm going to go with Rick Garnett's question for Mark, although others can, Mark can respond as well. With respect to the Masterpiece Cake Shop case, do you think it should be, as a general matter, relevant to the constitutional question that particular state actors express themselves in disparaging ways? More generally, should the constitutional question depend on inputs, motives, etc., or depend instead only on outputs or effects?
Okay, thank you. Hi, Rick. Thank you for the question. So I have to say, I'm a little blindsided. I haven't thought that much about this, but I would think, yes, I think it would matter that a government official disparages your religious belief, just as it would matter if a government official disparages, sexual orientation or something like this. I mean, I think part of the civil contract is government officials have to be polite about things and respectful about things. So I think it would be relevant. Now, I understand the pushback would be, well, does that mean the government can't express an opinion about anything that someone might find offensive? No, I don't think that either. I'm kind of in the mushy middle on most stuff, I guess, Rick. But basically, yes, I think it would be relevant in some important way if a government was disparaging a religious belief or a religious believer.
And the mushy middle may be one of the passive restraints or virtues. This is a three-part question, finally, from Andy Koppelman. One for each of you. For Stephanie, would an abortion restriction be valid if it banned the procedure even to save the life of the woman? Does that follow from the passage in Dobbs you quote at 12, note 34?
Is Andy on the line? Because I have a follow-up question for him about his question.
Well, I'm going with the chat here.
Right. So I guess my question for Andy is he asking, would a law like that survive rational basis review? Or is he asking, would the woman have some other constitutional basis, like notwithstanding a law like that passes rational basis review, would she have some other constitutional basis, presumably not a religious one, maybe some sort of due process one or other sort of constitutional challenge to the law? And so I'm trying to get a little bit more clarity on.
Okay.
I need to know more what Andy's asking about
Okay,
that.
let's wait on that for him to respond. Laura, consider a case like Liddell, I hope I'm pronouncing it right, in England, where the registrar asked only to leave the counter and have another one take her place to register the same-sex marriage. The couple would not even know why a different clerk was handling their application. Would it be appropriate to accommodate her?
Yes, this is an issue that I've actually wrote about in the paper to some extent, although he's certainly a good idea to follow up on it. This is the so-called, if you don't know about the act, it doesn't hurt you, basically. So if we somehow can hide an individual act of discrimination from the individual who is discriminated against, then that person has suffered no harm because they're not even aware that it occurred. The problem with that, in my view, is that it's not just the impact on the individual by knowing about the discriminatory issue and making it a discriminatory experience. It's the state's approval of that as an exception to that individual's civil rights. So, in other words, we could pass a law and say that there can be discrimination against LGBT people, Q people, there can be discrimination against Black people, against Muslims, against women, and so forth. And as long as you hide it from the individual, the state thinks that's fine. It depends on what you think the purpose is of the civil rights law. Is it simply and only to prevent psychological distress to claimants? Or is it, which Andy himself actually has written about extensively, is it to somehow change societal attitudes to make statements about what is and is not accepted in the community? That is a powerful argument for what these laws are supposed to do. And in my view, if you exempt individuals who have religious objection from that function by saying that as long as the person doesn't know about it, it's okay, to me, that undermines that entire theory of why we have civil rights statutes and what the importance of them are.
We have time really for only a couple more questions, and there's one last one for Mark from Andy Koppelman, and then we have our friend Tom Berg, who has a question for Laura, and then we'll wrap up with anything that the rest of you any of you have to say. For Mark, why is the significance of the status conduct distinction one for the Supreme Court to resolve? Don't state Supreme Courts have the final say about the coverage of their own statutes?
Yeah, hi, Andy. That's a very nice question. I know you talk about this in your paper too. I'm looking forward to. So this, of course, is the maneuver the court did in Fulton in saying that the state had gotten its public accommodations law wrong. Of course, you're quite right. Normally, we would say the state, Erie has not been overruled. We'd say that the state can decide, state can tell us what the state law is. But not always, of course. Sometimes the court is a little bit aggressive about things. And I guess even if even if the state law is interpreted a certain way, if the court thinks that's raising a constitutional problem, of course, that won't save things. But if the point of your question is, well, isn't this just a maneuver that the court was doing? I think that's what Justice Gorsuch calls it in Fulton. Isn't this just a maneuver to avoid a bigger question? Then I completely agree with you. I think it is a maneuver to avoid a bigger question.
Laura from Tom Burke, we may have a moment to catch up with that question that Andy asked Stephanie a little bit ago. But let's go with Tom's question for Laura. Is there any religious exemption you would support from a non-discrimination law?
I would have to say that the answer, this is tentative because I have not done a complete catalog of this. I'm currently in the process of doing that. I would have to say probably not, because if you're talking about something as vital as equal treatment in the public marketplace, now that's what I'm talking about. I'm not talking about private discrimination. I'm not talking about any of that. When you're talking about discriminatory acts against an identified group in a civil rights statute that deal with access to public services, products, settings, etc., I would have to say that I cannot think of any at the moment that I could support, because to me, the value of that there's a reason for no race exemption from civil rights laws for religious expression. There is a reason for no exemption for national origin in that situation. There's the law really is, there are no exemptions for religious objections in any other area of anti-discrimination statutes other than LGBT. So I'd have to say no.
Thank you for that. Stephanie, just to remind you and your colleagues, would an abortion restriction be valid if it banned the procedure even to save the life of the woman? And here is what Andy says. Can't the state say, it's sad that the woman will die, but you can't kill one person to save another?
Yeah,
Does that make more sense?
So to the general question, can states make distinctions about which lives they're going to protect or not under rational basis review? Yes, they do that all the time. So when a state decides to allow for assisted suicide in its state, or when it makes different distinctions about what will count as a lawful killing in self-defense, states are doing that. In a context with a case dealing with a religious claimant by a woman named Miss Diamonds, the state had said that they wouldn't allow her to receive a medical treatment consistent with her Jehovah's Witness beliefs respecting blood transfusions that would have allowed her to her life to be protected. And so, like, as a matter, the rubber doesn't meet the road under rational basis review. The question is there some other sort of constitutional challenge you can bring to those laws? And in the context of Miss Diamonds, she did bring a religious exercise challenge to that law. She would have won ultimately, even though she lost at the lower court. But by the time she would have won, it was too late. And she did die because the state didn't accommodate her religious exercise. So the question that would arise in Andy's sort of hypothetical is there some other sort of constitutional challenge a woman might bring? Maybe. I haven't thought about that. But as a general matter, do we allow states to make distinctions all the time about how they're going to protect human life and which human lives and which medical treatments, and whether they're going to do assisted suicide and who gets to engage in self-defense? Yes, that's like an ordinary function that government engages in all the time.
Thank you, Stephanie. And we're just about out of time. Does any one of you have anything to add before we wish you a fond farewell and take a break? Are we good?
I just want to add very briefly, Laura, I'm not sure that it's true that we just don't allow exemptions for other sorts of discrimination elsewhere in the law. Race is a unique category, in part because of the history our country has had with race and ways in which we have prohibited racial minorities from being full participants in society. But we allow an awful lot of exemptions for sex discrimination, including in legislation. And like, if all of your arguments about no, we should never allow exemptions were true, that means a lot of religious organizations would have to fundamentally shift even their leadership structure in terms of, do they allow women to have priesthood or certain roles or functions? And I think
No,
the better
no, no.
analogy,
Yeah, see, no,
let me just finish my sentence. The better
yeah.
analogy which Tom Berg has made is that LGBTQ discrimination is like sex discrimination. We allow an awful lot of exemptions for sex discrimination.
Okay, first of all, the category of gender discrimination when it comes to male-female discrimination is something with which our country has never really been able to deal. Witness the death of the Equal Rights Amendment after 40 or 50 years of pendency, right? So I agree with you that that kind of gender discrimination definitely has is in a different category as far as what the law actually is, and whether it's legislative or it's judicial. However, if we talk about all other kinds, race, national origin, religion, all other bases of discrimination that are out there, there are no examples that I know of where a religious objection to serving, for instance, we're talking about public accommodations, to serving a person who is a certain race, a certain national origin, a certain religion, has ever been accepted by American courts. It just has not happened. So it may be that someone wants to, or believes as a matter of policy, LGBT people should be placed in the same category as gender discrimination, and therefore we can do it. I mean, that certainly is someone's prerogative. I just, having lived with this community and seen the harm that is caused and so forth, I personally cannot endorse that position, but if somebody else wants to say that they believe sincerely that that's what should happen, that's simply their view.
Well, I feel, even though we're out of time, that we're just getting started, but I don't have the authority to continue this. I want to thank the three of you for outstanding and thought-provoking presentations. Professor Stephanie Barclay, Professor Mark Movsesian, Professor Laura Underkuffler, thank you so very much for making my job so easy. Take care. We are now taking a 15-minute break before our next panel, which resumes at 11:45, give or take a couple of minutes. Thank you again. I wish you all well.
Whether they're going to do assisted suicide and who gets to engage in self-defense, yes, that's like an ordinary function that government engages in all the time.
Thank you, Stephanie. And we're just about out of time. Does any one of you have anything to add before we wish you a fond farewell and take a break? Are we good?
And I just want to add very briefly, Laura, I'm not sure that it's true that we just don't allow exemptions for other sorts of discrimination elsewhere in the law. Race is a unique category, in part because of the history our country has had with race and ways in which we have prohibited racial minorities from being full participants in society. But we allow an awful lot of exemptions for sex discrimination, including in legislation. And like, if all of your arguments about no, we should never allow exemptions were true, that means a lot of religious organizations would have to fundamentally shift even their leadership structure in terms of, do they allow women to have priesthood or certain roles or functions? And I think
No,
the better
no, no.
analogy,
Yeah, see, no.
let me just finish my sentence. The better
Yeah.
analogy which Tom Berg has made is that LGBTQ discrimination is like sex discrimination. We allow an awful lot of exemptions for sex discrimination.
Okay, first of all, the category of gender discrimination when it comes to male-female discrimination is something with which our country has never really been able to deal. Witness the death of the Equal Rights Amendment after 40 or 50 years of pendency, right? So I agree with you that that kind of gender discrimination definitely has is in a different category as far as what the law actually is, and whether it's legislative or it's judicial. However, if we talk about all other kinds, race, national origin, religion, all other bases of discrimination that are out there, there are no examples that I know of where a religious objection to serving, for instance, we're talking about public accommodations, to serving a person who is a certain race, a certain national origin, a certain religion, has ever been accepted by American courts. It just has not happened. So it may be that someone wants to, or believes as a matter of policy, LGBT people should be placed in the same category as gender discrimination, and therefore we can do it. I mean, that certainly is someone's prerogative. I just, having lived with this community and seen the harm that is caused and so forth, I personally cannot endorse that position, but if somebody else wants to say that they believe sincerely that that's what should happen, that's simply their view.
Well, I feel, even though we're out of time, that we're just getting started, but I don't have the authority to continue this. I want to thank the three of you for outstanding and thought-provoking presentations. Professor Stephanie Barclay, Professor Mark Movsesian, Professor Laura Underkuffler, thank you so very much for making my job so easy.